Welcome back to another edition of the Wiccan Conservative. Today we are going to be doing Ray Epps Part 2, The Case of Ryan Samsel. The story goes that Ray Epps was in and around Washington, D.C. on January 6th prior to the quote-unquote insurrection, instigating and stirring up the protesters who had came to peacefully assemble and protest the Electoral College votes on that day. Now, one of the most famous people that Ray Epps has been suspected of influencing is this gentleman right here, Mr. Ryan Samsel. And his name actually came up in the MSN article that I showed to you in the first part of this series. So I wanted to get to the bottom of exactly what was in Mr. Samsel's case. Did he indeed have any reference to Ray Epps in his case? Was Ray Epps brought up in his case? And what exactly happened to Ryan Samsel? The first document that we want to take a look at is the actual complaint in regards to Ryan Samsel. So according to the criminal complaint for Ryan Samsel, he is being charged with forcibly assaulted, resisted, opposed, impeded, intimidated, or interfered with a federal agent while they are engaged in their official duties, committed or attempted to commit any act to obstruct, impede, or interfere with any fireman or law enforcement officer lawfully engaged in the lawful performance of his official duties, and obstructed, influenced, impeded official proceeding, or attempted to do so. In conjunction with the criminal complaint, they have a statement of facts sheet. They have him on multiple videos. They have multiple witness statements. And of course, they have the officer that was knocked over and eventually sent to the hospital with a concussion in his arms. They actually have a picture of that. The statement of facts regarding the case is pretty similar to the rest that we've seen with the January 6th defendants. What does get very interesting is the actual proceedings of the case. The first thing I noticed that was super weird about the proceedings of this case was the number of motions for continuance. So as you can see, on February 17th, 2021, the United States District Court for the District of Columbia versus Ryan Samsel issued a consent motion to continue the preliminary hearing and for excludable delay. They cited the government and counsel for the defendant have conferred and are continuing to communicate in an effort to resolve this matter. The current restrictions on counsel, particularly those impacting defense counsel's ability to communicate with her client, have slowed this process. The parties therefore would respectfully request that the preliminary hearing and the date by which an information or indictment must be filed be continued until April 1st, 2021. The parties agreed that failure to grant this continuance would deny counsel for the defendant the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. So what that means is basically the court, from the time that you are arrested, has a set amount of time before they officially arraign you on your charges, decide whether or not you are eligible for bail, and give you adequate time to confer with counsel in support of your defense. In this particular instance, we were told by multiple congressional members and by people who were family members to these defendants that they were being denied their rights in jails, that they were being held without bail, that they weren't being allowed access to their defense attorneys, and that their conditions in the jail were horrific. If you remember, Marjorie Taylor Greene and a few others, I can't remember off the top of my head, went down and actually investigated the standards and conditions of the jails and what type of mind frame that these defendants were in. But this wasn't the only continuance in this case. Filed again in March, there was another consent motion to continue the preliminary hearing for excludable delay. In this case, the government cites counsel for the defendant and the government have conferred and are continuing to communicate in an effort to resolve this matter. The current restrictions on counsel, particularly those impacting defense counsel's ability to communicate with her client, has slowed this process. Moreover, the defendant contracted COVID-19 while incarcerated, making him unavailable to defense counsel for 3 weeks and resulting in additional delay. So do you have to go back to the mainstream media who denied the conditions of the jail and the conditions of the defendants and say that they were so squalor that this defendant contracted COVID-19, which then impaired his ability to consort with his defense counsel to the point where now they have to give another motion of continuance? Or is this a COVID-19 catch-22 where he hit on a bad test and came up positive, which then delayed this process further? We don't know. The parties agree that the complaint will remain in full force and effect through the new date of May 7th, 2021. The parties therefore would respectfully request that the preliminary hearing and the date by which an information or indictment must be filed be continued until May 7th. The parties agreed that failure to grant this continuance would deny counsel for the defendant the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. This is another consent motion. This is from May 12th. This matter having come to the court pursuant to a motion to continue upon consent, it is therefore ordered that the motion is granted in part. It is therefore further ordered that after taking into account the public interest in the prompt disposition of criminal cases, good cause exists to continue the preliminary hearing to May 12, 2021, 1 p.m. before the magistrate, Judge Robin M. Merriweather. Parties should be prepared to address the issues related to the defendant's representation as well as the timing of the hearing of the May 12th hearing. Further ordered that the period from May 7th to May 12th be excluded from computing the time within which an information or indictment must be filed under the Speedy Trial Act, because the ends of justice served by such a continuance outweigh the best interest of the public and the defendant in a speedy trial. The court finds that COVID-19 has presented complications here that make it difficult for the defense to meet with her client and prepare, and that delay is necessary for parties to work on a potential resolution. So reading all of these motions of substitution, obviously we are jumping over a couple months and a lot of different orders and things that happened in between here. But this is just really, really wonky that, again, this is a pre-trial motion. The defendant has been in custody since this has happened. And now we are blaming this delay on COVID. Well, that would all sound fine and good if you didn't read any other parts of this case, because while I'm telling you that all of these motions are being moved around and delayed and this defendant is unable to get into a courtroom, on the back end, he is also attempting to get rid of his attorneys, different attorneys at different times. Now comes the defendant, Ryan Samsel, by and through counsel, moves this honorable court to substitute Elizabeth Pasquale, Esquire, with the undersigned counsel, Robert L. Jenkins, Esquire. So this is the first time that Ryan Samsel petitioned the court to change his counsel. The next motion comes in April 2nd. Motion to withdraw, motion for substitution of counsel. So this is where it starts to get confusing. Please pay attention closely. Ryan Samsel, by and through counsel, moves this honorable court to withdraw and strike from the record his previously filed motion to substitute Elizabeth Pasquale with the undersigned counsel Robert L. Jenkins. So he went in to see if he could substitute the counsel. For whatever reason, he did not want to continue forward with that. And the dates on this aren't too far apart. You're talking about the end of March 31st, and then he immediately files April 2nd to withdraw that claim. To me, that sounds like the defendant is not confident in counsel. He is either disagreeing with the way counsel wishes to move forward, or counsel is not communicating with the courts the way that the defendant wants to be represented. And I tell people all the time that lawyers are worth their weight in gold for a reason, because really good attorneys will listen to their client, give them real expectations, but still proceed in a manner that has their client's interest at heart. Other attorneys will not do that. They are either lazy or they pursue their own agenda, and then they charge you for it because they can do that. That's their job. From what I'm seeing, to remove and move these attorneys, the client is not satisfied. But that's not the only two attorneys that we have in this mix. Here we are in May. On May 4th, another attorney for counsel comes into play. I, Stephen Metcalf, hereby certify under penalty of perjury that the following is true and correct. He is the managing partner with Metcalf and Metcalf PC, located at Park Avenue in New York, New York. He's an active member in good standing of the State Bar of the State of New York, the Federal Bar in the Southern District of New York, the Eastern District of New York, the Western District of New York, and the Second Circuit Court of Appeals. He's a good member in standing of all the jurisdictions in which he's admitted to practice, never been disciplined by any bar, no disciplinary proceedings against him, and he had not yet applied for pro hac vici in this court. He did apply for pro hac vici in Superior Court of Dooley, State of Georgia, in the matter of Thomas Zervini versus Amy Smith, a civil action. That application was granted on or about 2020. He states he's familiar with the local rules of the court, and he wants to thank the court in advance for consideration for him to be admitted pro hac vici. Pro hac vici just means that even though you are not specifically licensed to that district's bar association, that you are familiar with the laws in regards to your client's case, and you're asking permission from the court to allow you practice in their district. Now, again, as long as you have no disciplinary actions against you, you should be in fine standing to practice with the court. But unfortunately for Mr. Samsel, that was not the case for the third attorney that he attempted to get to represent him. Comes now Stephen A. Metcalf, counsel for the defendant Ryan Samsel, requests leave of court to withdraw as counsel in support of the motion. Counsel states that the following: Ryan is currently represented by Elizabeth Pasquale, herein after Elizabeth, and his pro hac vici motion has yet to be granted. Interesting. Between approximately May 2nd and May 13th, Ryan continuously told undersigned counsel, that would be Stephen A. Metcalf, that he wanted to discharge Elizabeth, which meant fire, and that if the undersigned could not proceed, Ryan wished to proceed with the defenders or with the federal defender's office, and that is precisely the reason Ryan contacted that office in the first place. So everything that I've told you is true according to this motion by Stephen A. Metcalf, who is signing off on his knowledge of what Ryan has said to him about his counsel, his representation. On May 14th, a hearing was held where neither the undersigned counsel nor attorney Rob Jenkins were present or notified of said hearing. Remember, he has 3 defense attorneys. So only one defense attorney was formally notified, according to Stephen Metcalf, and was able to appear on the hearing on May 14th. So imagine you're a defendant in a federal case like this, and 2 of your 3 counsel just don't show up to a hearing. 4, upon information and belief during the hearing on May 14th, Ryan stated on the record he wanted to continue with Elizabeth. So again, I threw that out there so that you would have an idea of what this is like. So if 2 of the people you contacted to represent you don't show up and only one person does, and that's the person you happen to be trying to get rid of, you kind of feel like you're stuck between a rock and a hard place, and the judge is sitting there looking at you for an answer. During the hearing today on May 18th, Stephen continues, Elizabeth and the government raised the issue that there may be a conflict with the undersigned office. Now, this is really interesting when your defense attorney goes on the side of the government to object to another defense attorney who's supposed to be on the same team as you. 6, it is undersigned counsel's position that to fully explain the issues of how no conflict exists would require him to reveal attorney-client privileged information, which he is not willing to do so. And of course, he's not only not willing to do so, he's legally bound not to do so. 7, by undersigned counsel withdrawing, he is not leaving Ryan without counsel. Ryan can continue with Elizabeth or obtain other counsel, which Ryan indicated unequivocally up until the day before May 14th that he would hire the federal defenders if Metcalf and Metcalf would or could not proceed. 8, it is in the interest of judicial economy and to avoid any more confusion and unnecessary allegations, it is in the best interest of the undersigned counsel and Ryan that the undersigned withdraw as counsel, and it is not necessary to have continue into attorney-client privileged conversations as to settle the issue of attorney representation. Last but not least, in light of this and in furtherance of the undersigned's pro hac vici application having yet to be decided, it is respectfully submitted that Stephen Metcalf be permitted to withdraw as counsel and that his pro hac vici application be stricken from the docket. Wherefore, undersigned counsel respectfully requests to leave to withdraw as counsel for defendant. So, again, with all of this information being sealed and inaccessible to the public, we are left standing here holding the bag on what exactly happened between Mr. Ryan and his 3 defense counsels. According to the defense counsel that wasn't even permitted to the case officially through the courts, this is something that Ryan himself wanted better representation, and it all stemmed from the issue with Elizabeth, who in Stephen's words seems to be siding with the government on what Stephen could bring to the table in Ryan's defense. Okay. What else goes into Ryan's state of mind? Well, we don't have to ask. This is a status report for Ryan Samsel. Herein lies another defense attorney. So I told you this was confusing, right? Remember the story I did about John Pierce? Yeah. So it seems that John Pierce also represented Ryan Samsel. And John Pierce, before he went MIA, and if you don't know who John Pierce is, please go back to the archives and look up the John Pierce video. I have already explained who he is and what has happened to him, or at least what we thought happened to him at the time. Long story short, he was representing Ryan prior to his disappearance. And this is his assessment of the status of his client. Okay, I'm sorry. I told you this is very confusing. John Pierce claims defendant Ryan Samsel, by and through his attorney, submits this status update ahead of the emergency status hearing calendared for August 5th, 2021. So we are now into August, okay? August 2021. The purpose of this status update is to inform this court regarding Mr. Samsel's representation, his health, and the conditions of his confinement. Mr. Samsel is represented by Pierce Bainich, PC, and John Pierce as lead counsel. However, Mr. Samsel is seeking other counsel to assist in his case. So that explains now how he has obtained John Pierce as counsel and is attempting to create a team of lawyers to assist in his defense. Mr. Samsel is presently being detained at the Central Virginia Regional Jail and has been so detained since. So again, like I told you, they arrested him, detained him, transported him, and still have this man in custody. We went from January 30th, 2021 to now we are in August 2021. The concerns arising regarding Mr. Samsel's safety post-surgery for the lack of care and Central Virginia Regional can provide. Further, Mr. Samsel has been wrongfully assigned the status of sex offender from Major Haywood of Central Virginia Regional. Because of such status, Mr. Samsel has been moved to a cell that he is not allowed to leave. After informing counsel of such conditions and the assignment of the sex offender status, Mr. Samsel's firm contacted AUSA April Russo. Russo contacted Major Haywood via email regarding the incorrect classification and was assured by Major Haywood the classification had been updated. However, there has been no change. Again, we talk about the mainstream media telling us that these people were not being denied due process and that these things were not happening. Yet here I'm finding in these court documents that is exactly what's happening. So after all of this, what happened? What eventually happened with Mr. Samsel's case? So if Ray Epps was not the one who initiated this, and we can't find Ray Epps's name anywhere in these court cases, and the defense for this gentleman has been lacking and has hit every road bump possible in the court system, what on earth could they have possibly done to this man, and why didn't we hear about his final disposition? We heard that Ray Epps was cleared. So what about this guy? The United States of America, by and through its attorney, the United States Attorney for the District of Columbia, respectfully moves the court to issue a protective order governing information related to a summary letter, an investigative report, and its attachments involving contractor A. These documents contain personal information pertaining to an employee, contractor A, at the United States Attorney's Office. The government is requesting a protective order for these materials in many criminal cases throughout the district court and superior court in producing these materials, although the incident they involve occurred in a different case. The United States has consulted with the defense counsel about the protective order. Defense counsel consents to the filing of this motion. Respectfully submitted, Channing Phillips, acting United States Attorney, April Russo. So what this says is it's going to seal the information related to a summary letter and an investigative report and its attachments involving contractor A, which we have to assume is the sensitive information and investigation details that went into what was actually happening inside those jail cells, how these people were getting these weird classification statuses, how they were being locked down, and who actually inside the jail cells were responsible for this behavior. So that's a plus. We won't be able to look at any of these investigative reports because they contain personal information pertaining to the employees of these facilities. But last but not least, the original docket case for Samsel has been terminated. So through the entire process, and while the mainstream media continues to beat on about Ray Epps and how innocent and he's not associated with the FBI whatsoever, we have seen a complete deniance of your civil rights by the court system in real time through these court documents. Then at the end of the case, we find out that the entire thing is terminated, closed, done, finito, no final disposition. And if you remember correctly, this is a defendant who was wanted in a different area for different crimes. So you have to start asking yourself, what exactly did these people say? What exactly is redacted from the record for them to come now to a conclusion? And throughout all of this, you notice they didn't really ever go to court. They didn't go through the jury trial. The defendant didn't even have a plea. They never got to a trial. And the case is terminated. Done. Terminated 8/25/2021. Represented by Elizabeth Pasquale, John M. Pierce, Robert Lee Jenkins, Stanley Edmund Woodward, Julia Hazua Haller. Pending counts, none. Highest offense level opening, none. Terminated counts, none. Highest level of offense terminated. Complaints. Complaint in violation of 1811, 18231A3, 181512C2. Those were the complaints against him that have zero disposition. That's the end